So I just got another great question from a viewer that I wanted to answer on today's channel. The question is, so my spouse has cheated on me. Does that help me win my case? All right, so let's dive in. Let's see if we can answer that question. I'm Tom Marks with the Marks Law Firm in Orlando, Florida, and welcome to the Healthy Family Law Attorney. So you caught your wife, husband cheating, and you want to know in the divorce, does that help you win your case? Well, number one, Florida is a no-fault divorce state. You don't have to prove grounds in Florida like adultery, cruelty, abandonment, and so forth. You just allege, quote, the marriage is irretrievably broken, and whoever pleads for that, files the petition, is going to get the divorce. However, adultery does come into play in a couple of situations in Florida. If you look at the statute, number one, adultery comes into play for equitable distribution. So what does that mean? So we're dividing up the assets and liabilities of the marriage. And you found that your spouse has cheated. Well, if they have engaged in what's known as wasting of marital assets, meaning that they've spent any monies on the relationship during the marriage that are considered marital funds. So they've bought the, we call them paramour a lot of times, girlfriend, boyfriend, gifts. And these have to be fairly substantial gifts. We don't want to get into little trinkets, but jewelry, vacations, trips, cruises, hotel night stays, very expensive dining, things like that. What the court can do is equalize the equitable distribution. So I've had many cases where we've shown that there's been a waste of marital assets. And we've had some cases with a waste of in the hundreds of thousands of dollars. And so let's say each of the parties is going to get $400,000 of a total $800,000 in equitable distribution, but the other side has wasted $100,000. So that $100,000 comes off the top to my client, our client, and reduces the total amount of the remaining equitable distribution available from $800,000 to $700,000. And so then each of the parties splits that $700,000 remaining equally, so $350,000 each. But my client got the first $100,000, so my client got $450,000, and the other side got $350,000. All right, the next place that's relevant is in the area of, quote, moral fitness. So this is a little tricky because it can't be just that the other side has had an affair or is cheating and it's had no impact on the minor children. It's only where really it has an impact on the minor children that the court's going to take note of it, with some exceptions, which I'll get to in a minute. So I had a case where the other side, basically their bedroom door was a revolving door, and the minor child was there when that other party was having one affair after another in a separate dwelling that they were in, even during the separation. So that had a direct impact on the minor child. There was psychological issues that it created for the minor child. And the court actually, that's one of the factors the court still has to take into consideration under the statute chapter 61.13 sub 3 A through T. Those are the factors, those 20 factors. And I've done a 4-part series on my YouTube channel on those 20 factors that the court must consider. But this factor, the court considered very heavily and awarded not only sole parental responsibility to my client, but also the vast majority of overnights and time sharing and required supervised visitation or time sharing contact with the other party. So does cheating make a difference in whether the court is going to award the divorce or not? No, because we're a no-fault divorce state. I should mention that if you were looking in the Florida statutes under Chapter 61.08, the alimony statute, it's still in the statute that the court can consider adultery when determining the amount or whether alimony is awarded. That is really no longer the case. You can't just read the statute, you have to also know the case law. The Florida Supreme Court has ruled that the trial court cannot punish the adulterating spouse in terms of awarding more or less or no alimony based on adultery. Okay, so with all that said and what the law is in Florida, I'm going to tell you that judges are still human beings and they're still impacted by bad behavior of the parties. So I've seen many times where a judge comes down hard against the party that was committing adultery or cheating without coming out and saying why they're doing that or that they're doing it because of the cheating. But again, judges are human beings. If they feel like that other side the cheating was really pervasive and in the face of your client and did have an impact on the minor child, and there was a waste of marital assets, and it was just gratuitous and it was significant, then judges oftentimes will hammer that party. So it is, I think, from my experience, and I've been doing this for 35 years, depending on your judge, is potentially very significant in the case, depending on the level of the cheating. Okay, so I hope this video has been helpful. Please share it with somebody that you think it may be helpful to. Please keep those comments coming because I love answering these questions like this. Would love it if you'd subscribe to the channel, hit that like button, and keep watching videos. I'm shooting new legal videos like this that are posting every Wednesday, and I'm shooting new interviews with other professionals every Friday. They get posted. So thanks so much for being part of the channel today, and I'll see you next time.